A technological update. The best known application of blockchain technology, which many are now beginning to understand, is notoriously the Bitcoin. Even with other virtual currencies, it has fluctuating values, but continues to be popular as a payment and a financial instrument. Worldwide, and also in Italy, case law is constantly dealing with it. The Italian Court of Cassation has recently ruled that anyone who buys bitcoins with financial means of illicit origin commits the crime of self-money laundering. This confirms once again that bitcoins can be considered as a financial and speculative instrument, and that as such it can be considered a technically suitable instrument for the commission of the aforementioned crime. All the more so because it allows transactions to be largely anonymous, and therefore it is very carefully monitored. For this reason, those who purchase bitcoins must always take care to keep documentation to prove the legitimacy of the funds used. And what about NFT or non-fungible tokens? They are another practical use of the blockchain technology itself. First and foremost, they are used to make the originals of digital works of art recognizable and marketable with interesting different uses, depending on whether they are linked to tangible work of art or not. But also in the field of fashion, for example, they are progressively being used in a manner accessible to any consumer to ascertain the uniqueness and/or belonging to a limited series and/or, in any case, the authenticity of a specific material product. These and many others are the possible uses that are gradually becoming more widespread, so it is important for everyone to understand at least the elementary rudiments of this technological tool. The indexing and the oblivion right. Since the 2014 leading case of the Court of Justice, Google Spain versus Gonzalez, both are considered right related to the protection of personal identity, its correct expression, as well as its protection in the social sphere. In particular, the indexing of a specific piece of information consists in a request to the search engine or the operator of a website to no longer make it available through indexing procedures. In this context, the search engine ought to be considered as a different and additional subject to the subject that published the news. In a very recent judgment, number 21415 of 2022, the Italian Court of Cassation ruled that this right does not exist in an autonomous and absolute sense, but may be exercised according to criteria of proportionality and reasonableness. In the relevant case, it denied that such a right of the applicant existed, even though it was considered as an expression of the right to privacy or as an autonomous right of personality, because the court held that the protection of important matters of public interest, as provided for in Article 23 of the GDPR, prevailed. This latter rule, in fact, sets cases in which the public interest prevails over that of the individual citizen.